Hi everybody, my name is Kyle Patterson. I'm the Director of Business Development and Culture here with Bryson Insurance. With me is Kourteny and Corette, and I will get into more formally introducing in a couple minutes. Also just sitting off the screen here to my right is Mark. He will be watching for questions, and so what we're asking for is for everybody to ask their questions as we go. If we're able to answer them throughout the presentation, we will. If not, we'll make sure to answer them at the end. But as you have a question, please type it so that you don't forget to ask it. So this webinar is on Bill 148. We all know the bill has now passed, and this webinar is all about helping prepare you to see where you're at today. So what we're going to cover first is why this is an important webinar. Also, what has changed within Bill 148? What are the immediate steps that your business should be considering? And what recommendations from these two should you consider? And then what questions you have. Now, in this webinar, it's unique because we have people who are in businesses that are smaller, who may not have a lot of action to take, and we have obviously larger businesses too, where there's a lot of changes to make within the organization. And there's also people with varying levels of knowledge and skill on this already. Some of you have probably been to a couple live events or webinars, and for some of you, you may have only read our compliance bulletin. So this is open for any type of question. So why this webinar? So Bill 148 has come, but it's actually come very quickly, and there's big changes happening fast. We find it important as an organization to bring awareness to you, and it's easy to miss aspects of the changes. There's lots of nuances and small pieces inside of the legislation that it's important to get clear on. And I'll get into talking about this, but company reputations are also on the line. There is more inspectors being hired, and we are discovering that lots of people have questions, and they're not always clear of where to go to get answers. So we thought, hey, why not actually bring two people very versed in this who can help answer questions for you. Yeah, we hope. Yeah. Now, part of what you should have received, and if you've not received it, feel free to reach out to myself or whoever invited you to this webinar, is our compliance bulletin. This actually reviews the bulk of the changes within from a summary and high level point of view. And provide you a lot of context to work through. Also recently in the news is the Labor Minister, Kevin Flynn, said he's hiring up to 175 new inspectors in Ontario to start enforcing this new law. And it's hard to sort of measure what does that mean, like 175 new inspectors. So last year, the Ontario Labor Board, or the inspectors, actually conducted over 40,000 proactive inspections. So those are ones that are random. You don't know they're coming. And over 30,000 inspections based off receiving some sort of call or notification, a reactive type of inspection, which would be like an employee reaching out to them saying, hey, can you come and inspect my organization? And so we find it really important to be ahead of the curve here and take on the action to be in compliance. And so at this point, it's my pleasure to now formally introduce Corette and Kourteny from New Initiatives HR. Now, combined, they have over 15 years experience in the HR profession, and New Initiatives HR is actually celebrating their 10th year in business. 10 years ago when they opened up, they started off in Toronto, and 3 years ago opened up an operation here in the Durham region to serve our clients, their clients locally. And what's unique about them is that they've served a wide array of companies, from large international brands in the private sector to public institutions as well, everywhere from manufacturing to food services to tech companies to those in the healthcare and personal services industry. And they're really adaptive and flexible, which I find wonderful as well, so that they can sort of jump into various cultures and different business enterprises and contribute and add value. And inside of this Bill 148 conversation, what I found with them is that they've, this has happened, and there's nothing that we can do today except for prepare ourselves. And they've taken a very positive spin on this discussion and are really trying to make it, a positive outcome for your organization. So at this time, I'm going to introduce these two.
Great, thank you. Thanks. I'm Corette. So thank you for joining us today. And as mentioned, we are trying to help do a quick overview of the law, but also trying to have an HR focus towards it, and trying to be positive and help adapt to what has come onto our plates and learn how to deal with it as an organization. As Kyle mentioned earlier, there's a lot of big changes, and they are fast. And in over the 20 years around, I've never seen anything happen so quickly under the Employment Standards Act. And that's why there is the hiring of the 175 officials as well, because the Ministry of Labor also has to try and prepare for all these changes that happen so quickly. So we can totally get the apprehension that employers must have right now. So we're going to try and give you some quick guidelines to help to get you through that, and help you get prepared for the changes that are now in effect. So. With the 175 new officials that are hired, they most likely be focusing on the changes of Bill 148 alone, solo, probably for, I would say, I'm going to guess at least the first year, 6 months a year, because it is going to take time for all employers to get everything into place. But I wanted to remind you that there are still other blitzes, and the Ministry of Labor's website, which supports the Occupational Health and Safety Act and ESA, do have other blitzes still in place, and those blitzes are still around the safety, because it is an area that employers still can't forget about, keep a focus on. And at any point in time, if you're wondering what blitzes are happening in Ontario, you can go on the Ministry of Labor's Occupational Health and Safety section, and it will highlight. So, the most recent ones is blitzes on safety within the retail and restaurant industry, as an example. Okay, so that's it. So why is this important? It's interesting to see that slide of, the 40,000 or more proactive, this one, the proactive, searches, or not searches, sorry, drop-ins with clients. Keep in mind, even though you're in Durham region, these are not focused only in Toronto. There is a strong focus in Durham region, and about a year and a half ago, they actually posted that they were doing blitzes in Durham region. So it's one of the misconceptions that I hear the most from clients in this region, is that we're a small client company, we're a small organization, they're not going to worry about us. Well, they are. And we have some clients that range from 2 employees up to 85, and they have been had Ministry of Labor officers knock on the door, surprisingly, and they're only a staff maybe of 15. So don't, just kind of keep in mind, don't think that you're hidden with the fact that maybe you're under 20 staff, or that you're in Durham region alone. Okay, that's good.
And just to answer Edith's question first, and I see the other two above, which we'll come to through the presentation, but she's asking that they're federally regulated. So is there a part of Bill 148 that impacts them?
There may be parts of it, anything that especially has to do with the human rights aspect of it, but most of ESA really focuses on the provincial. It's a provincial versus federal. What are your thoughts?
I think that if you have an office in Ontario, it most likely will affect you. I would think, even if you are federally regulated, your office is still in Ontario, so I feel like you would still have to abide by Bill 148.
I know we have a couple of clients who are federal regulated, and they're adopting, some of the provincial aspects of it to keep competitive within their region. And so,
yeah, that's exactly it.
Okay, beautiful. So this is now valuable for you too.
Okay.
So are you ready to go to the first slide here?
Yeah. Sure.
Okay.
So we really thought that Bill 148, as you know, can be a half-day seminar, actually. So we thought, let's focus on what have been some of the most popular questions to date. And of course, one of the most popular ones and concerns, the immediate concern is the minimum wage. So we put up the chart here so everyone can see what the minimum wage is, and you can see the changes that came into effect of January 1st, 2018, and the changes in 2019. Now, this was quite a dramatic increase for under a year or under a year notice. You know, so the largest increase was for home workers at $2.6 increase. So now, Ontario's been going through and experiencing increases in our minimum wage over the last 4 or 5 years, but nothing so dramatic in such 1 year. So we really didn't have time to plan for this and budget for it, but we have time to put in plan and budget for 2019. I'm already hearing from clients that they've already implementing that increase now. We're planning to implement it halfway through the year so they can kind of just work towards their budget towards that way. So it's definitely going to have an immediate impact on all businesses. But some people believe that it might, that will actually improve productivity and retain your employees, and they're going to stay longer. So obviously, if you have a reduction in your turnover, you're going to have a cost savings immediately. It's just an automatic cost savings as soon as we have that.
Excellent. And just for clarity, I don't think it impacts a lot of people here on this webinar, but home workers are people like, does that include PSWs or is that more so nannies?
There would be a lot of nannies, like your home care.
Okay.
Yeah, individual home care net workers. So, which is good to know because, you know, a lot of don't realize that they should have clear employment contracts and terms and conditions for home workers. So, okay. Yeah. Okay, so I'm going to have Kourteny talk a little bit about the statutory holiday and the calculations.
Yeah, so obviously we've covered the minimum wage, which was huge, and I think that's what most people focused on when we were switching to Bill 148 and the changes were coming. But some of the changes that people are just becoming aware of is the stat holiday and the calculation for that. So previously, what the calculation was is that you took the 4 weeks before the vacation or the stat holiday and you divided that by 20. Now, with Bill 148 since January 1st, if there's a stat holiday, you take the 2 weeks prior and you divide it by the days that the employee worked. So if the employee worked, 4 days during that 2 weeks, you're just dividing the days that they worked by 4. So if they averaged out, they did a 7-hour day or an 8-hour day, you're paying them the 8 hours. Whereas previously, it might have, say for a part-time worker, it might have just come out to 3 hours. This is something that we've tried to get our clients to implement in the past before anyways, because a lot of times employees are taking the stat holiday because they have to, and they're getting less pay. So that definitely impacts your business and your culture. Yeah.
And it reduces some of the admin tasks too, and the time that it takes to sit and calculate when you're just doing the calculation in the last pay period versus the calculation in the last, so many weeks, 4 weeks type of thing.
Yeah.
It's much easier for you.
Good. Did you want to talk about
Yeah, did you want to talk about the vacation increase?
Sure.
Yeah.
Vacation increase. So in employees now in Ontario eligible for 6% or 15 days, which is equivalent to 3 weeks vacation, upon completion of 5 years of service. Questions that are coming our way, is it at the beginning of the 5 years? And no, it's upon completion of 5 years service with you. And it's regardless if it's full-time, part-time, casual, or temporary. Your tenure is your tenure. You don't have to be working 40 hours of weeks. Now, to be competitive in the market, offering 3 weeks or 6% after 5 years, still, not as attractive to certain industry. Definitely depends on what industry you're in. We have seen, and I have seen employers are offering the 6% in the 3 weeks right up front. So, and that might be something that you can consider if it's something that you can put in as an attraction. So, to have employees look at you versus your competitor, right? Type of thing. Say offer above and beyond. So. If you have any policies that are current in place and you need to adapt or want to adapt, keep in mind you definitely can. You just have to be greater than what the Employment Standards Act is right now. So.
Yeah. So vacation kind of leads us into more time off work that employees are entitled to, and that would be the personal emergency leave. So now, beforehand, the personal emergency leave was only available to companies or corporations that had 50 or more employees. Now they've taken away that threshold, and it's any employer. So even if you have 1 or 2 employees, your employees are entitled to those 10 personal emergency leave days. And what that encompasses is, I saw someone ask about sick days, that does include illnesses. So illnesses, deaths in the family, family illness, kind of encompasses all that. So you can actually create a policy where your sick days are included in the personal emergency leave days. Within those 10 days, the first 2 are paid. So you would have to pay the employer for the first 2 that they take. And that starts after 1 week of employment. So your employee can be there for 1 week and they're entitled to that. It can be a summer student, even though they're there for 3 months, they are still entitled to it. Part-timers are entitled to it. So it's kind of...
So before this, probably what would have been more normal is after probation.
Yes.
People then had this, and now it's almost instantaneous.
Yes. Yeah. And there's also been a ban on doctor's notes. So the government or the Ministry of Labor hasn't really said what you can ask for. They said that you can ask for evidence reasonable in the circumstances. We don't really know what the clarification is on that. You just can't ask for a doctor's note. So,
which is typical. So one of the things you'll want to do is to look at your current policy and what the definition is of your emergency leave, or you know, a lot of our clients have a policy in place called unexpected absences. So under the unexpected absences emergency leave, and it's not just a personal illness. That's another misconception. It could be you have an emergency on your way and your car broke down, or it could be on your way and you got a call about a family member. You know, your nanny or daycare has an emergency shutdown for some reason. Those are what considered emergencies. So it's not just illnesses. However, employees are expected and encouraged to book all appointments, the typical dentist appointment or doctor's appointment outside of your standard work hours. Now, we also say encourage, keep in mind when working dealing with specialists at any point in time, because we all know how difficult it can be to get a specialist appointment in the evening, right? So we want to consider with that. So, but the no doctor's notes and no physiotherapies, things like that are definitely not allowed during those first 10 days.
Wow.
So after your...
So I guess it expands, right? So then what you're saying is now if someone's car breaks down, that does count. Whereas before, an employer could say, hey, I need still a doctor's note. Yeah. So this kind of just frees that up.
You know, the biggest concern is employers are asking how we're going to performance manage somebody who is a chronic, has absent issue, right? That's one of the areas you want to focus on. Yeah, within the first 10 days, or the first 10 days, they have that eligibility now to have that time off for the emergency. But what I will do is I always encourage conversations, open, honest conversations with your staff. So sit with them and say, hey, listen, you know, Betty, you are at 5 days already, and we're only in March, and 3 out of those 5 are every Monday. That's showing a pattern. So you could want to highlight that to them. So bring awareness to them, because if they can go, oh, I didn't realize, or you're setting the path for future performance management conversations with them. So
beautiful. And we have some questions here too. So you did answer Lily's first question, and so she's just looking to clarify the stat holiday pay. It was I don't know if you can read that there, but it was mentioned that the calculation was changed to the last 2 weeks worked prior to the holiday. However, ESA states last pay period. We are paid weekly. So
I guess the standard pay period is mostly 2 week.
Yeah, that's what we meant.
But it is. It's your last pay period for sure.
Okay, beautiful. And Fatima there asks, so his first question was around 7 personal emergency days in the automotive industry. Is that exception? Is there an exception for the auto industry?
That one, I would have to look up and confirm. I can follow back on that one, because there is definitely under ESA, there are some little parts of industries have exceptions. So that one we can follow up. And give an answer, because I know this is coming out, right? So we can follow up with some clarifications. I'll be happy to clarify that one for you.
Sure. And then there's another question in there too around the doctor's note, being able to show that they're healthy enough to return to work.
Yeah, so that would be part of your disability management program. So that's when somebody is off for a longer time frame, definitely not within the first 10 days, because really the employee does not have to tell you why. They can just simply call in and say that I'm taking an emergency leave day, personal emergency leave day, and they don't have to tell you why. It could be for any of the reasons that we kind of gave you a description of. But if somebody is off on a disability for a longer time frame, or is chronically ill, you do have a right to ask for a return to work note, because it is to ensure that, one of the requirements employers have is to ensure that employees are well enough to be on the work site. So definitely, but that's under disability management, and it would be a much higher absenteeism rate than the 10 days.
Beautiful. And Kim asks, so their vacation schedule is based on a calendar year, but if someone actually completes their 5 years of service in August, when do they actually get that? I just have to jump up.
Do they have to start in 2018 or 2019? I think.
Right.
Just upon their anniversary.
On their anniversary?
Mm-hmm.
Okay. So that become a prorated to the end of the year?
That's correct.
Okay. And just so, okay, and then we'll move on after this from this one. Just so that we can clarify, out of the 10 personal emergency leave days, we are obliged to pay employees for 2 of those days.
Yes.
Yes.
It's the first
employer.
2.
Yeah.
Okay. And then Martin wrote in a question early, just saying that they actually provide their employees six sick days, so they're not impacted by this change.
No, they're just gonna, now they can, out of those 6 days, employees now are eligible for additional unpaid.
Okay.
Right? So that's a good example of a policy that's above and beyond the Employment Standards Act, but they should also look at their calling procedures and what their requirements are of evidence and stuff like that, and ensure that they remove anything that refers to doctor note. What standard you'll see a lot in policies is after 3 consecutive days or 5 consecutive days, a doctor note is required. That's no longer a requirement. Also, too, around the stat, if I can just back for quickly, sure. Because the before and after time frame, if the individual calls in sick normally after a stat day, if they are pulling in and saying I'm taking an emergency leave day, then you can't ask for any evidence around that. However, if the emergency leave days are all used up and someone's calling in sick after a statutory holiday, then you're allowed to ask for a doctor's note. So it really comes down to keeping an eye on those dates.
We just want to make sure that our clients and you guys know, just keep track of those things. A lot of clients, they'll get an email saying that an employee's off and they won't mark it anywhere. They're not calculating and seeing how much that employee's at until they're over the 10 days and they're well over. We've seen clients with 20 days off for an employee that they haven't been tracking, and
and we'll get into that, I think, later on in the recommendations.
Yes.
And so another big change in here is the job protected leaves.
Yes.
And so here they are, and you guys can speak to these.
This is a list of all the leaves that you will find under the Employment Standards Act. There's 2 that are specifically new there, the domestic and sexual violence and the leave for death of a child. Kourteny is going to spend some time to talk about the domestic.
Yeah, so the reason we want to talk about the domestic and violence leave is because under the Occupational Health and Safety Act, you are required as an employer to keep your employees safe while they're at work. If you think that your employee is being abused or is in a domestic abusive relationship. Now the government has upped that and said, the Ministry of Labor, has said that now an employee who claims that they're being domestically abused at home or their children are being domestically abused can have 15 weeks off and 10 days, the first 5 of which are paid. And those 15 weeks don't have to be taken consecutively, and neither do those 10 days. What this is actually doing is it's allowing employees that are in those relationships to leave that relationship. It's allowing them time to move and find a new house. It's giving them the time to go seek medical attention if they need it, see if, like a psychiatrist or anything, if there's any mental abuse there to the children or themselves. It's also allowing for them to use social services that are offered in the case of that domestic abuse, or to search legal help if there's anything in terms of, are they bringing that person to court or are they fighting for custody of their children? So that's a big one that a lot of people are asking questions around. The employee needs to let you know as soon as they're going to be taking that leave. It's hard to say when an employee should come to you and tell you that they're going to take that leave, because I think a lot of times abusive relationships, oftentimes I think they don't want to let people know that they're in that. And the employee has the right to privacy during that time as well. So obviously, please don't announce to your other employees that that's the leave that an employee is taking.
That's going to probably be one of the biggest challenges, is trying to keep the privacy of the individual who's experiencing such a thing, but while also providing them with the time off that they need and the support that they need, so, and the protection.
Do you have any recommendations too, just in that one in particular, on creating sort of that workplace where now your company, your staff know that it's okay to come forward with this type of situation?
I think that has to do with your culture. Like, we talk a lot about culture at New Initiatives, and creating a culture of trust and of communication. And if employees know that they can come to you and they can speak to you when something's happening in their lives, I think that that's an important thing.
We like to, I recommend having an open door policy of some sort, like the typical whistleblower policy. I'm not a fan of that title, but an open door policy. So if you're smaller organizations, clients, you can have an external party manage that for you. So someone, a trusted party, and to support where they can call in and they can seek out advice and recommendations and support. If you're a larger organization, then you normally will have somebody in-house that the employee is going to feel comfortable going to.
Sure.
Right. So, but it is trying to support that environment of wellness and comfortness. So when they're going through.
And in this one as well, and I'm also staying really present to the time because we still have a lot of material to look after.
Yes.
But a lot of people who go through that type of violence actually go back to an abusive relationship. So how does this leave impact if somebody were to go back into that relationship again?
It's not per lifetime, it's per year.
Per year?
Yeah.
Okay.
So, because it's not our decision really to make for them. It's the employer's obligation to protect them. And that's on the health and safety side under the Nonviolence and Bullying Act, to protect them while they're on site with their security measures, which is a conference all on its own.
Sure.
And then now also provide them the time. And like we said, it's some days are paid in up to 15 weeks. So, and it's under the job protective leave. And what's important to keep from all these leaves under job protective leave is that an employee's vacation still continues, their benefits continue. So anything that they would have as an active employee as a perk or benefit they're still eligible for.
Sure. And not to jump to a different one, but for example, with the extended parental leave, the EI is just spread out so that payment's the same, like that those benefits are the same, but the actual their group or health benefits, that continues on. So that's an added cost for an employer.
Yes.
Yeah.
But we actually have two questions that one I think is really great here from Kathy, because it's a very sensitive topic. So how do you ask for evidence or proof if an employee does make a claim for domestic?
It's still, from what we've read, and we've been on lawyer sites and we've spoken to lawyers, it's still the same threshold as the personal emergency leave of asking for evidence reasonable in the circumstances. I think it's a very delicate matter, and it's hard to tell an employee, like, show me proof. I just think you'd have to take your employee's word for that. I don't feel like people are going to be saying that they're being abused when they're not. I mean, I would say a very minimal percent of the population would ever take that risk. So I would say it'd be hard to ask for evidence.
I think, as I encourage with any of them, any of the absenteeisms or any of the leaves, and especially if someone's chronic, is as an employer, take the approach as being positive and trust that your employee is, communicating with you what's happening with them. And then if they're showing a pattern, as I mentioned earlier, if they're showing the pattern that there's possible abuse, now have a one-on-one conversation with them. But don't, I know this is old saying, but just because there's one apple that's bad in the basket doesn't mean they're all bad, right? So I say approach with positive and approach with trust with your employee, and they will communicate with you. But if they feel that they're being there's any punitive that can come after having a conversation with you, they're not going to communicate with you. They are going to hide.
Sure.
things from you.
And I think, and I'm looking at Alicia's question too, and maybe there's some clarification there, but basically asking if the days they're taking off are sporadic under that leave, are only 2 of the days paid if it says it's for emergency leave?
Yeah. Sorry, go ahead.
Go ahead.
And that's where the trust is going to come from, if they're explaining to you why they're taking it off. Because if they're saying to you, this is an emergency leave, and they're not giving you details, then you're going to record it as an emergency leave. Or the domestic leave is separate, so it's a different leave altogether. So if they are sharing that as that, then you would record it under that leave. So it's recording it under 2. But again, it's getting to the employee to share that with you.
Absolutely. Okay, and Kim has a great follow-up on this general conversation, which is their employees pay for 50% of their benefit.
Yeah.
Are they able to ask their employee to prepay?
Yes, that's a very popular question. Especially, yes, you can, and definitely when it's a leave that's planned, for example, the maternity and parental leave, you can ask for them to pay it up front ahead of time. I've seen organizations go, okay, great, you're going to be gone in 6 months, so we can take extra deductions off your paycheck per pay period. Or you can just, some organizations will allow post-dated checks throughout the time that they're gone, but most employers definitely, you can ask, want the leave paid for upfront before they actually go on leave. But if it's a last like an emergency leave or a domestic leave, that they're not usually planned, right?
Sure.
Under the definition of emergency. So when you can communicate, it's very important on any leave to always stay in communication with your members while they're away. Don't let them go away in the abyss. Keep them connected, and then you can inform them that they are going to be required to pay that premium. Depending on how long, I always recommend, one of my recommendations is to send them a letter outlining what the payments and the requirements are, and then what the consequences will be if they don't pay. So most employees don't want to lose their coverage because it's going to be very difficult to get back onto the benefit coverage. So, but definitely you can.
Okay, so we're going to have to scoot along here
Okay.
and into another big area, big conversation.
Yeah, the difference between an employee versus contractor. So very popular to hire on independent contractors into our workplace, especially at a 6-month time frame, which is great if it's a short term. But where ESA is focusing on is having an independent contractor long-term or permanently, when it should actually be an employee. Most are aware of that. This is something that CRA has always focused on in the essence because of lost taxes being paid, right? So they have a checklist. ESA is adopting, it's almost identical kind of checklist that they'll come in and go, are they on your site? Are they under your hours of operations? Are you giving them direction on a day-to-day basis? Are you providing the equipment, et cetera, et cetera? Are they only solely working for you? So if that's the case, then most likely they're going to be defined as an employee. Even if it's part-time or a casual employee, if they're not working for anyone else, if they don't have any other contracts with anybody else, they're going to be an employee. So you'll want to really take a look at that, because now it's just not the taxes or the back taxes, it's the eligibility for benefits, the eligibility for vacation, eligibility for any other perks that the regular employees may have, right? So healthcare spending counts, lifestyle spending counts, like gym memberships, things like that. So if ESA comes in and as an employee, they will be eligible for it, and they'll be eligible for the back pay of it. So
how do they do that test to determine?
It really is a questionnaire. Most of the times they will question the employee separately, and then they'll question the employer and fill out the checklist, and they'll analyze it depending on who's on the other end, who's analyzing it, if they'll come on site or if they'll just do it virtually through questionnaires. So,
Okay.
yeah.
Great.
All right.
Record keeping.
Yes.
I'm gonna let you talk about that.
Okay, record keeping. So before there was a threshold of keeping your records under the Employment Standards Act for 3 years, they've upped that to 5. What we suggest to most of our clients, though, is to keep in line with the CRA requirements of keeping records for 7 years. Just because you would never want Administrative Labor administrator come in and say, can you pull this file? And you're like, well, I got rid of it, actually. I think it's just best to keep the 7-year mark.
Then it's consistent across both the departments.
So you're not looking through and saying, oh, this is for CRA, we have to keep this for 7 years, but we can only keep this for 5. The things that you need to keep are dates and time the employee is scheduled, when they've actually worked, canceled shifts, so obviously personal emergency leave, that kind of stuff. If you've ever called them off, keep that in a record because of the scheduling that we'll talk to in a few minutes here. Written notice of the statutory holidays, retention of records, so that would mean like their employment offer letters, their health benefits, anything that would have to do with their employee files, I would keep it in a file. And we like to tell our clients, document everything. Any conversation you have with an employee that you think you'll have to maybe touch upon at a later date, keep that in the file. It'll help you going forward if there's performance management issues, if there's an issue to terminate someone with cause, you have that record and you can pull those up. You have the dates, you have proof. So it's not only about employees getting greater benefits, it's about you as an employer protecting yourself.
So employers were always required to have employee files and records. Now it's just extended to what's required in them. So even so much as the job application and resume is in there. What's really important too is to ensure that those employee files are under lock and key and kept quite confidential and limited access. If a Ministry of Labor inspector officer was to come, that's one of the things that they're going to look at is say, let us see an employee file. They want to see how they're stored.
I see.
Ideally, sometimes they want to see them in fireproof cabinets, but they don't normally penalize an organization if they're not in fireproof cabinets, but they will see. So what there is there just the extension of what's required in it.
Great.
So,
Thanks. And you have this little note in here about the scheduling the minimum 3-hour shifts. I don't know if you want to discuss this. I'm just considering, you know,
how much time do we have?
Out of time left. We have about 4 minutes left. I think we can extend past this. We can come back to this.
Yeah.
Can the employee files be PDF and not paper?
Yes, because a lot of individuals, and we were going to mention, a lot of individual companies are going completely paperless and going cloud. So we were going to talk about scheduling using a cloud-based system. Sling is there's a little picture there. Sling is a free application that you can use to do scheduling, and it's an app employees can have on their phone, so it's easy to connect. But yes, with the employee files, if you have you can do a PDF on your computer system. Ideally, it would be good to have a very simplistic human resources system. I'm a fan of Bamboo HR, but and then you can upload that, and then you and the employee has access to a copy of anything that's in their file. And another reminder, employees are allowed to see what you have placed in their file, so it's not just for yourself.
Okay, great. Thank you, Christine. I see a question coming from Kathy, so we might jump back to that, but we can, so if you can see that there, is there a problem if the employee files are kept off-site?
No, however, wherever you've kept them, if it's, say, for example, a home office, now that becomes what the ministry considers as a work site, part of your work site. So they will have regulations on who has access to them and locked up. So anyone who have confidential client files and or employee files, you should ensure that you have a lock on the cabinet and a lock on your office door. And if that way, then you are being compliant of ensuring private and confidentiality for the employee. So. Okay. So this is new.
Yes, posters.
New posters. We love our posters. Good Lord. Go ahead.
Okay, so on the left here, you're going to see the poster that you've probably seen. I hope it's posted in your workplace. It's the Employment Standards Act poster. So it goes over vacation for employees, hours of work, scheduling, all that jazz. And now you're required to have the newer one with all these new changes. So the one on the right there is the newer one. And what you would be required to do is post this in your break room or somewhere where you have a health and safety board, just so that all employees can see it. And you are required to give a copy to each one of your employees. You can do this by just sending an email of a PDF to them directly. And you can find this on the Ministry of Labor website. It's a quick, just find it, print it off on a quick 8x11. You can post it that way, and then you can send it to your employees. But it's just a way of letting them know the changes. And this just kind of shows good faith that you want them to know what their rights are. It's again promoting that culture of open communication, that open door. Yeah,
it really promotes trust, right? So don't try and hide anything from your staff. It's really great to have that open back and forth. Here's what your rights are. we as an employer are committed to ensuring that you have a safe environment, that you know what your rights are, you know, type of thing, and where you can go for further information. And that's really the intent around the posters, because there are actually more posters than that, but this is the newest one that's out.
And this one's mandated. There is a fine if you do not have this.
Yeah, I believe it's around $300. So.
It's a quick, easy thing to do.
Mm-hmm. Yeah.
And so we're now moving into what's next, and this is another big conversation as well. So we may be going about 5 minutes over time just to make sure that we get this one covered too.
Sure. So effective April 1st, 2018 is equal pay for equal work.
Okay, and what that means is if you have two people that are in the same job function, they need to be paid the same amount. So what that means is that if a job is substantially the same, what the Ministry of Labor is saying, even if it has a different title but it has the same job description, those people need to be paid the same amount. And what we tell our clients is to always keep a job or a pay structure. Why is someone getting paid more in a certain job than another person? Is it their tenure? Is it their education? You really have to show what the structure is for your pay to prove why one employee isn't getting paid as much as another. And if an employee asks why they're not getting paid as much as someone else, you have to write to give an answer, and it has to be in a written form. So I don't know if you want to touch on that at all.
So you can just say, it's really kind of taking us back to being, again, documenting and putting everything in writing and highlighting. Here's the different grade levels. You can have one job, but you can have different levels in it. So as in your organization and your HR team really should work with you now to sit down and go, what are the different levels, and identify what those levels are. Is it 1 to 2 years? Is this 3 to 5 years? Is that type of thing? Puts you at a level 1, level 2, level 3. So when an employee does come forward and inquires around, you know, what's my pay rate, and I don't think I'm getting paid the same as somebody else, your response has to be in writing, but you can show what the justification is, saying, here's the level that you're in. And you know, they can't argue if it's 2 years experience and they're still within those 2 years, then that's the level that they're in. So
to on Lily's question here, so like, you know, just imagine you have like the job description written, and for everybody who's doing the same construction job, it's the same job description. And so now, if this was now enacted, all those people should be paid the same. So then how would someone like Lily create distinction? And you kind of touched it there, but for that,
yeah, she's actually highlighted herself, because they're in the job for more years, so that's years of experience, right?
And should you write that right in the job description at the bottom, like creating tiers or levels?
I would recommend, right, that way, that when you're posting the job description or the job posting, you're highlighting all the requirements from that job, the technical, the educational, you know, the work experience, that type of thing. And you're identifying right there what the levels are, and then start putting in level titles, you know, director level 1, director level 2, you know, type of thing.
And another thing would also be that a part-timer is entitled to the same amount as a full-timer. So if they have that same job description, they have that same job function, they're entitled to that same amount.
That's what's been happening a lot in the employment field, is part-time workers and casual workers are getting paid less for the same work than a full-time person does. So most of our clients that we've worked with for over the years, I've just given them an easy solution. If you're 40 hours a week, that's 2,080 hours a year. So take your, you know, full-time salary, 50,000 a year, divided by 2,080, and there's your hourly rate. So that way you're the same. It's the equal pay.
Right.
And your temp. And same as with temporary workers as well. If their assignment is going to be longer, if I remember correctly, I think it's 3 months. So if you're using a temp worker that's going to be on site with you longer than 3 months, they're eligible for equivalent pay as well.
And so this, like, even this conversation may be confusing to some people, because how it's written in the bill really seems to specify that it's for part-time, temporary, casual, and seasonal employees doing the same job. But it also, in that same bucket, is 2 employees doing the same job who are both full-time, or 2 that are both part-time.
Yeah.
Right?
Yeah, exactly.
Okay.
And really we've attended a few conferences with different law firms. So I think that this is still going to play out a little bit on how it's actually going to be measured over the next 6 months, especially once the Ministry of Labor themselves get comfortable with
I
it.
think a lot of this is just, it hasn't been brought to court, nothing's been challenged yet, so we don't actually know what the threshold is going to be for a lot of this and what the common law is going to end up being for a lot of these cases. So.
And John has a question too, because I know this has come up, right, around paying for performance. Is John sort of saying, different employees are paid, but they have different production results based on their performance?
I was just reading that. It's hard for me to give a 100% accurate response on that, John, but I would say it sounds like a variable pay to me, without seeing your details. But if it's a variable pay, almost like a commission, right, then I would say the commission rates can be different, right? Everybody can have different commission and variable pays. It's really coming down to the base pay. We're the ESA. Do you have anything to add on that?
I would also say just document it. If it's based on performance, make sure you're documenting that it's based on performance.
Yeah.
Have you done a performance review? Is that in their employee file? So that then if the Ministry of Labor ever came, why is this employee getting paid more than this one? If they're in the same job function, you then now have a record of that to say, this employee has this on their performance review, this employee has this.
Yes, so if the job is, a laborer or installation of roofs, and they're getting a variable pay on how many roofs they do, make sure the measurement is done on quality, not just the numbers. But you can say that they get a bonus, which is a variable pay based on the number of roofs installed. Hope that makes sense.
Yeah, and what's good about this one too is this one could be catching you off guard right now on this webinar, and you have a little bit of time before this one is coming into force.
So in the lawyers are still trying to interpret, so we do have like 3 months to kind of work this one out a little bit more detailed.
And then your last point here on the ESA inspectors.
Yeah, in the red, do not refuse an ESA inspector or an officer at your door. Violations and penalties, they seem to be we haven't seen a massive increase. They do continue to highlight that any major violations, normally on the health and safety side, that there are fines up to $25,000, $50,000, $500,000, jail time if there's a death due to an accident. So that's a whole new code on its own under the criminal code. But some of the basic fines for non-compliance under the ESA are anywhere from $1,000 to $5,000. It really depends. Right? So because the Minister of Labor supports the ESA and the Occupational Health Safety Act, so when an inspector arrives for any reason, they may be coming for one reason, but when they do an inspection of your property, they can come across other violations. But we will always highlight, do not refuse them. They have power. People ask me, don't they have to have a warrant? OPP has to have a warrant. No, they don't have to have a warrant. They have a right to come in and check your employee files and anything to do with your employment related.
And now under Bill 148, they have a right to publish the name of your business publicly and say what the offense was or the violation was of the bill. So again, that comes to recruitment. If you're trying to get good employees in and they see your name published, that might be a little bit harder on your business.
That's what Kyle was talking earlier about your reputation within the community. So depending again on the industry, Glassdoor.
This person's asking, what does ESA stand for?
Oh, sorry.
No, sorry, Employment Standards Act. I realize that those two are the same thing.
Yeah, they are. The Electrical Safety, Employment Standards Act, ESA.
And I skipped over this slide, and we can only touch on it here very briefly, because it's good to know that you don't necessarily have to have all of the changes fully updated and in action today. You could have sort of a plan in place. If you guys can elaborate on that.
They did. I mean, obviously they're encouraging, and they would like to have to see employers compliant from as of January 1st. But really, the bill didn't come into play until November, so it was not a lot of time to plan. So we're like, implement your HR playbook, and really this is outlining what's your strategy from now to the next 3 months, and the next 4 months, next 6 months. what you can get in play, and what are some immediate things that you can just knock off your list. One, employment contracts. Those set up the terms of employment, no misunderstanding between you and the employee. And as I mentioned earlier, it doesn't, regardless of position or industry, everybody should have an employment contract. Also, you know, to update your Bill 148 into your established policies and procedures, and or create one. So get an employee handbook or guidebook in place as soon as possible. That will really help highlight and get you somewhat compliant in ensuring that your policies are up to date. So under both the Employment Standards Act and the Occupational Health and Safety Act. So those are some really quick ones. And so therefore, if you have your place, if an inspector was to show up at your website, your website, they're going to be a lot more understanding and work with you, and they're going to give you a little bit more time frame. They'll be great. Okay, you got a plan in place. You're being proactive, or you're doing something. We'll come back in 45 days. Versus, you know, being giving you a fine right off the bat. They're going to work with you. So.
Okay, and I believe Kim's writing a question, but in the bit here about employee acknowledgement, I know we've had to sign something.
Yeah, definitely. When you roll out your handbook and guidelines, always get your employees to sign off an employee acknowledgement form that they've received it and that it's their responsibility to read and understand it. But on top of that, be proactive and again, create that culture of back and forth, open conversation and communication and trust, and train your staff. Take them through a training session, sit with them, have an open forum where you're explaining to them what the new changes are and what the requirements are, and you're encouraging them to ask you conversations and ensure that there's clarity.
Beautiful. And jumping right down to the bottom, thank you all too. So we recognize that we went on an extra 10 minutes, and that was a large part because there were so many great questions coming through that were relevant to the slides that we were on. So we thank you all for participating and being here with us. Thanks too for Corette and Kourteny.
Thank you
for giving us their time. We do, if there's any last minute questions here, feel free to type them in. But one thing that these two have offered our clients is a free 1-hour consultation just to do a quick check-in to see where you're at right now and potentially highlight what gaps that would need to be covered or what direction to take, similar to our second set of eyes analysis that we offer. You also see the government's website there, labor.gov.on.ca. Kim, to answer your question, yes, I will send out a copy of the slide deck, but you will also get a link to the webinar, which we will send out once we have it up and live. Is there any final comments you two want to make?
That's great. No, if you have any inquiries and you want to take advantage of the free 1 hour, send in an email to our contact information there. But please ensure to mention this webinar.
Yeah.
Beautiful. All right. Thank you, everybody.
Great.
Have yourself a wonderful day and take care.
Thank you.